Sometimes fences may require a party wall agreement if the fence is exactly along a property line. Common driveways also require an easement outlining how the driveway will be maintained. Most lenders will require these agreements be in place before lending on properties, like the ones we have discussed. Easement by necessity. This easement is an appurtenant easement and is granted by the courts in the case of necessity. The best example is a landlocked piece of property. In other words, a parcel of ground is inaccessible because it is surrounded by property owned by others. All property owners have the right of ingress and egress, or the right to access their land. An easement would be necessary to protect the owner's right of access. The court could grant an easement by necessity to the landlocked owner, allowing them to access the property over the land of another. It is important to note that this type of easement is indeed an easement by necessity. A property owner may not ask a court to grant an easement to give them a more convenient access to their property. The easement will only be granted when absolutely necessary. Easement by prescription. An easement by prescription is established by continuous use of another's land for a certain period of time. Each state has different requirements. Some jurisdictions will allow tacking, which is adding the use of several owners or others with ownership interest together to meet the statutory requirement for the length of the use of the ground. For example, if tacking were allowed, Grandpa's use of the neighbor's property to access the river every day for 10 years would be added to the son's use for the following 10 years after the son inherited the property. Let's review an example. Chad lives next to a college campus. Every weekday on his way to work, Chad takes a shortcut through the campus. Chad does this for 25 years. The statutory period for establishing an easement by prescription in Chad's home state is 20 years. One day, the college decides that they are only going to allow students, faculty, and other staff to enter the campus. Does Chad have the right to enter the campus? If Chad is able to prove the other required elements of an easement by prescription, Chad may have an easement right. This would grant him the legal right to take a shortcut through the campus. What if Chad had only occasionally cut through the campus? Chad could not satisfy the continuous requirement of creating an easement by prescription. What if the college granted permits for cutting through the campus, one of which Chad held for 25 years? If Chad had a permit to cut through the campus, he was driving through campus with the consent of the college. Therefore, Chad could not claim an easement by prescription. Let's review another example. Whitney lives next door to Elizabeth. Whitney raises ponies, but does not have room to park her pony trailer. For the past 10 years, Whitney has parked her pony trailer on Elizabeth's property. Whitney decides to sell her mini ranch. The new owners also raise ponies and continue to park their pony trailer on Elizabeth's property for another 10 years. The statutory time period for establishing an easement by prescription in Elizabeth's home state is 15 years. The time that Whitney and the new owner used Elizabeth's property as a parking lot may be added together to satisfy the statutory requirement for length of use, to establish an easement by prescription. Assuming the other requirements are met, the new owner may be granted an easement by prescription. Easement by condemnation. An easement by condemnation is taken by a governmental authority for the public good, under the concept of eminent domain. We cover eminent domain extensively in another course. For example, a city may need an easement to run a phone cable across a farmer's ground. If the city is able to satisfy the eminent domain requirements, the city may demand the easement be granted by the farmer. The farmer must be compensated if the easement results in a reduction of the value of the property. Encroachments. An encroachment occurs when an improvement on one property illegally crosses the property line onto an adjacent property. For example, a fence may extend onto the property of a neighbor. This would be an encroachment. The playhouse a homeowner built for their kids in the backyard may have been placed partially on the neighbor's property by accident. This would be an encroachment. Encroachments are often discovered through a physical inspection. However, a survey may be necessary in order to determine the exact property lines.